Who can serve as a guardian? Choosing who can serve as a guardian in Texas is a deeply personal decision. When a loved one can no longer manage their own affairs, the choice of guardian affects the individual's well-being and the entire family. Guardianship is about trust and responsibility, and a wrong decision can leave someone vulnerable. Because of the stakes involved, families look for guidance when navigating this process. Texas law provides a framework to protect those who cannot make decisions for themselves. A guardian is appointed by the court to manage a person's personal or financial affairs. The Texas Estates Code governs guardianship and ensures that a guardian is appointed only after a court determines the individual is legally incapacitated. Courts use guardianship as a last resort and must tailor the appointment so it interferes as little as possible with the person's independence. Texas courts have clear rules on who may serve. The law requires that a guardian be an adult resident of Texas, although the court can approve an out-of-state guardian if they have close family ties and meet additional requirements. Applicants must not have convictions for crimes involving dishonesty, violence, or moral turpitude. The court will also examine whether the person has conflicts of interest that could interfere with their duty and will exclude anyone whose history suggests neglect or abuse. Meeting the requirements is only the beginning. Judges also consider whether the proposed guardian has the financial responsibility, moral character, and physical ability to care for someone else. Even if someone is eligible, they can be disqualified if their own work, health, or other obligations limit their availability. A legal guardian manages another person's affairs under court supervision. Guardianships come in different forms. A guardian of the person makes decisions about health care, education, and living arrangements. A guardian of the estate handles finances such as paying bills and managing property. When a person is totally incapacitated, a court may grant full guardianship, giving authority over both personal and financial matters. In other situations, a limited guardianship allows the ward to retain certain rights while a guardian assists only with specific tasks. The types of guardianship reflect the state's commitment to balance protection and independence. Guardianship is used for people who need support because of mental or physical limitations. Adults with intellectual or developmental disabilities who lack capacity to make decisions about health, finances, or living arrangements may need a guardian. Mental health conditions such as severe bipolar disorder or schizophrenia can lead to guardianship if the individual cannot care for themselves. Physical disabilities alone do not automatically require guardianship, but the court may appoint one when a condition impairs someone's ability to manage essential tasks like paying bills or seeking medical care. Elderly adults facing dementia or other cognitive impairments may require guardianship to protect them from exploitation or neglect. Minors whose parents have died or are unfit may also need a guardian to handle their upbringing and financial matters. Texas courts often prioritize family when selecting a guardian. Parents are usually the first choice for minors or adult children with disabilities, and spouses are preferred for elderly adults. If a spouse or parent cannot serve, adult children or other close relatives may be considered. Sometimes family dynamics or conflicts make it necessary to appoint a friend or professional guardian. Courts will look beyond relatives if there are conflicts of interest, neglect, or financial disputes. Judges also weigh multiple candidates' qualifications and relationships to the ward, and they can appoint a neutral third party when family disputes are too intense. Texas allows co-guardians in limited circumstances. A court may appoint co-guardians when it is in the ward's best interest and the guardians fall within specific categories, such as spouses or joint managing conservators. If two people do not meet the statutory criteria, the court may still divide duties by naming one guardian of the person and another guardian of the estate. Co-guardians must work together, and significant conflicts can lead to court intervention or removal. Out-of-state guardians must appoint a registered agent in Texas and may be asked to post a bond and file more frequent reports. The court also assesses whether a non-resident can manage local duties, such as traveling for medical appointments or overseeing property. Selecting a guardian requires evaluating potential candidates honestly. Applicants should consider whether they can dedicate time and effort to meet court expectations. If multiple relatives want to serve, cooperation is crucial. Otherwise, the court may appoint a neutral guardian to avoid further disputes. Ultimately, the goal is to safeguard the ward's rights and ensure they receive the best care. Families who are uncertain about the process can benefit from consulting a knowledgeable lawyer or attorney for guidance. Deciding who can serve as a guardian in Texas impacts a loved one's future. With careful planning and advice from a guardianship lawyer, families can protect vulnerable relatives and preserve their independence. The Law Office of Whitney L. Thompson, PLLC, located at 4201 Farm to Market 1960 Road W Suite 360, Box Number 116B, Houston, Texas, 77068, provides compassionate support and legal guidance to families navigating guardianship. For personalized assistance from an experienced attorney, call 281-214-0173.